Good afternoon. Senate Judiciary and Public Safety Committee will come to order. Today is Wednesday, April 15th, and we do have a 2026 for the record, and we do have a quorum present. Senator Hauschild, you're the first up. Members, Senate File 4548 relating to non-disclosure agreements. The plan is to discuss the bill, take an amendment, and lay the bill over for possible further action. Senator Hauschild, go ahead.
Thank you, Mr. Chair and members. Before we begin, I do have the A3 amendment, which is a technical amendment, just changing some wording based on council's recommendation.
So, members, this is technically not an author's amendment, but it's pretty self-explanatory. You have the A3 in front of you. So any discussion or questions from members of the committee on the amendment? Not seeing any. Senator Clark moves adoption of the A3 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Hauschild.
Thank you, Mr. Chair and members. This bill is about balancing economic opportunity with transparency by banning NDAs for local officials on data center projects. Oftentimes when I talk to local officials, they tell me that they want to compete for economic development projects, but many have told me that they also feel pressured to sign NDAs just to stay in the running. Even when they're uncomfortable, they worry that saying no means losing out. And I can say, as a senator from the most rural district in the state, this is particularly apparent in rural and more regional areas of the state that are really trying to compete for job-creating opportunities. My bill would create a statewide standard by banning those NDAs for local officials, which would remove those pressures among localities trying to compete for one another for these opportunities. This bill makes clear that no community has to choose between attracting investments and being transparent with their residents. It levels the playing field and reinforces that public decisions should be made in the open. And this doesn't stop projects from moving forward or prevent companies from protecting proprietary information. It simply ensures officials can do their job with accountability to the people that they represent. At the end of the day, this is about building trust while still supporting growth. And with that, Mr. Chair, I am more than happy to take any questions or if there's any testimony. Thank you so much for the opportunity to have a hearing.
Thank you, Senator Hauschild. I don't have anyone signed up to testify. There has been a letter from the Chamber of Commerce distributed as in our packets to members of the committee. Any discussion from members of the committee? Senator Limmer.
Thank you, Mr. Chair. Senator Hauschild, there may be some businesses that may feel as though they might be potentially revealing a process or a trade secret, something like that, that they don't want competitors to know. Would they be forced under this law to, if this became law, to disclose issues like that if it was part of a non-disclosure agreement?
Senator Hauschild.
Thank you, Mr. Chair, and thank you.
Openness of a non-disclosure.
I'm sorry, I missed
the openness of a non-disclosure.
Thank you, Mr. Chair and Senator Limmer. So this bill is particularly targeted at, well, it's exclusively targeted at data center projects. So I was very explicit about that. I could see circumstances where, for example, in Hermantown, where I was a former city councilor, a growing, budding community wanted a Trader Joe's, let's just say. And a Trader Joe's may want an NDA in order to protect their proprietary information with competing grocers in the area. This bill does not impact that type of decision. But given the broad impact as well as the sort of global companies that are building these data center projects, it's my sense that they are particularly that transparency is particularly needed in our local communities on these specific projects. So that's really why it's targeted at them versus like a grocery store or something else that the community more generally would support.
Senator Limmer, follow-up?
No.
Senator Holmstrom.
Thank you, Mr. Chair. Senator Hauschild, in my district, we have a few large data centers looking to build multi-billion-dollar investments, and the pushback from the community on this is that they're nuisance buildings, that these particular entities are going to create a nuisance in the community, similar to like we talked about racetracks or anything that has an effect on that around it. And I look at this bill and I wonder why so narrowed? Is it common practice to create laws that are broad enough to say none of this agreement, but only for this very small sect? It would make sense if we were tying it to all sorts of nuisance organizations or industries, but you've just picked on one. And I'm wondering what's so special about data centers that doesn't apply to anything else, racetracks, what it might be.
Senator Hauschild.
Thank you, Mr. Chair. Thank you, Senator Holmstrom. There's been a pretty wide bipartisan effort, particularly as it relates to data centers, both in the House as well as in the Senate, just with regards to some of the developments that have happened in local communities, some of the transparency concerns that have come up. In northern Minnesota, we have a project that's being considered whereby I've even talked to elected officials who have said, I'm mad that I signed the NDA. I wish I didn't have to stay competitive for these types of projects. And so that's why it's really targeted at data centers because of a particular circumstance that has occurred in my region. And I think you're seeing that sort of across the body's bipartisan agreement that, we need to look at this particular case, these particular cases.
Senator Holmstrom.
Thank you, Mr. Chair. I definitely understand what you're saying there. I'm concerned from a policy perspective whether or not it's good policy to target such a specific industry with a law. And I think that kind of what's good for the goose is good for the gander. Either it's good to get rid of these agreements altogether or it's good to have them. And there's other legislation looking to do that. I don't know where it's at in the process, but I'm concerned about just picking on one industry and setting that precedent. Thank you.
Senator Kroon.
Thank you, Mr. Chair. Kind of to that point, I see what you're saying in terms of if this prohibition applies to all of the local units of government in the state, then they don't have to worry about one city having an advantage over another city because they're all playing by the same rules. I understand that, but I guess I don't know the economics of the macroeconomics of this enough to know how often for these data centers are local units of government competing with communities out of the state of Minnesota who this law would not apply to, and whether that would put them at an economic disadvantage in that scenario.
Senator Hauschild.
Thank you, Chair Latz. Thank you, Senator Kroon. I think Minnesota is clearly a place that these types of data centers are looking to build. I think we're seeing that with our climate, with the sort of framework that we have in our state. They want clean energy. That's something that Minnesota is leading on. That's what I've heard from many of these groups. So I think, there's definitely competitive advantages that we have as a state. And I think you're really seeing nationally, not just locally and regionally like we just talked about with Senator Holmstrom, but really nationally sort of a discussion around these and how we can have transparency around them. So I anticipate other states having these conversations as well. And no, they quite literally are as we speak.
Senator Kroon.
Thank you, Mr. Chair. And I can appreciate Senator Holmstrom's point too. It seems a little uncomfortable to target one particular sector. On the other hand, I really don't want this to just be like the previous bill we heard, to just be for everything because in those scenarios, to me, we're very clearly competing with out-of-state interests that would put Minnesota at an economic disadvantage. So the narrower this can be to target whatever it is that we're trying to target, I think makes sense. Even though I'm a little uncomfortable singling out one specific thing here, but this bill is certainly a lot better than the last bill that we heard, which I had serious problems with it applying to everything for those reasons. So I'll appreciate your testimony and answering my questions. Appreciate it. Thank you.
Senator Holmstrom.
Thank you, Mr. Chair. Senator Hauschild, to a point that Senator Kroon brought up, so Minnesota is unique in our water resources in a lot of ways that make us attractive to data centers. But does Iowa and Wisconsin, are they not competitive in the same ways? And if so, are they considering, do you know, language doing the same thing? I'm just trying to make sure that Minnesota in our region is not giving ourselves, tying our hands behind our back.
Senator Hauschild.
Thank you, Chair Latz, Senator Holmstrom. I don't want to answer incorrectly. My understanding is for sure Michigan is considering some sort of NDA and also broader framework on data centers. I'm not familiar with Wisconsin or Iowa specifically, although it's possible that they are.
Senator Limmer.
Thank you, Mr. Chair. I had an opportunity to skim the letter from the Minnesota Chamber of Commerce. And there's a paragraph here that raises, from a business perspective, their concern about this bill. It simply states, in practice, non-disclosure agreements are commonly used during economic development discussions when companies must share sensitive operational, financial, and site selection information while determining whether a project is viable. Without some level of confidentiality during those conversations, companies may be unwilling to explore potential projects in Minnesota. You know, in an area such as yours, Senator Hauschild, I know there's always a desire to bring more jobs to that region. And there's limited opportunities for a narrow field of employers to actually come there due to transportation issues, lack of a sizable employment base, or perhaps they're not schooled in a particular area. So then the corporations would have to provide their own training in order to facilitate a wider employee base. I think I agree with the Chamber's view on your bill. Whenever we're dealing with issues involving privacy or transparency, we always try to find that balance point where we benefit both sides. The Chamber, speaking on behalf of businesses, revealing their concern that this may be a little too broad. And for that reason, I'm most likely will have to oppose the bill. I like transparency, as many people know, but in this case, I wouldn't want it to be stifling economic development when there finally is an opportunity to bring it to outstate regions where employment is minimal. Apparently, you may not share the same concern that business have, but have you heard from other businesses in that area or wanting to come to that area in your corner of the state? And have they shown any concern about this type of thing? Or is it a grin and bear it, well, I guess we're going to have to do this, even though it may reveal some of our business practices and make us a little less competitive in other areas of the country?
Senator Hauschild.
Thank you, Chair Latz and Senator Limmer. I agree with you that we have to be competitive as a state for economic development. In northern Minnesota, we have fought for many economic development projects for many years that would provide family-sustaining jobs, as you've described. However, we can't just assume that those opportunities come without proper transparency for our communities. And I have heard overwhelmingly from constituents that certainly that opportunity should be there, but we should know about rezoning, we should know about project proposals, we should know about what's happening in our community when the project is the scope of a hyperscale data center. That's not to take sides on the hyperscale data center itself, pro or against, but communities do deserve to know that information, and frankly, not to defend politicians, but politicians should not be beholden to an NDA that they sign that they don't even really realize what it is, and then feel like they can't communicate with their very constituents who are crying and screaming for information about projects. So there is definitely a balance here that I think you are describing, which is how do we promote economic development and these types of opportunities while ensuring that constituents and local officials feel like they are being, transparent and forthright with the information that's before them. So, this is a budding industry. It's growing. It's happening very rapidly with the advent of new technologies among our global technology companies. And Minnesota, alongside the nation, is learning how to handle these properly. You wouldn't build a paper mill or a mine in northern Minnesota without proper transparency. Let's make sure that's the case with data centers as well.
Senator Clark.
Thank you, Chair Latz. Thank you, Senator Hauschild, for this, your bill. I want to talk a little bit about the power imbalance that you were describing there. I think we need to reflect a bit on what we're talking about. We're talking about Google, we're talking about big, giant companies who are well practiced at getting into these NDAs and doing negotiations, coming into a spot where they are not as well practiced. They maybe have worked well with Casey's, they may have worked well with Trader Joe's, as you said, but Google is a little bit of a different animal, and that's where I start to wonder about inadvertent violations of the NDA. If a city council member, a councilor from Hermantown, inadvertently violates the NDA, what trouble is that city councilor in? Is it the city councilor individually, or is it the city of Hermantown that is on the hook for whatever violations and monetary penalties civil penalties they may go after for violating that NDA?
Senator Hauschild.
Chair Latz, Senator Clark, I know you're speaking in hypotheticals, but just for purposes of clarity, no city councilors in Hermantown signed an NDA. So I just want to make sure that that's clear. It was actually some county commissioners. So I just want to make sure for the record that that's on the record. But also, I don't know the details of that. I'd be curious if council might know the answer to what sort of the penalties would be for. I guess it would depend on the NDA maybe, and what the agreement is. But it is a very good question. Are individuals responsible for inadvertently breaking an NDA, or is it on the city? I think it's a very potent question.
I would think it'd be on the city if they're acting in the course and scope of their duties as a public official.
Yeah.
Ms. Primo, any thought on that?
Mr. Chair and members, some of this will depend on what that NDA states, and because that violation would be a breach of that contractual agreement. I am assuming as long as the person was acting within the scope of their employment, it's possible that the city could defend and indemnify or be involved in some way, but because it sounds like, at least for some of these NDAs, it's a specific individual who's agreeing to the terms, it could potentially be on that specific individual.
Senator Clark?
Thank you, Chair Latz. Thank you, Ms. Primo. And that's sort of my assumption, and to the point that it's, the city councilor of Lake Wobegon is not going to have had, they're bringing in a risk that I think the city and the councilor may not fully understand in this power imbalance. So I think that's where this is trying to make sure we're helping our small towns and our small communities have a little bit more power in all of this. Thank you.
I think I'd also worry about a city councilor meeting at a meet and greet on the shores of Lake Wobegon, knowing in her head that there's this massive data center planned half a block away on the shores of Lake Wobegon, and feeling kind of compelled to let the neighbors know that this might be coming, and maybe hint, oh, there's something big coming, but I can't tell you what it is. It creates some pretty untenable conflicts there. But I worry a little bit about these big developments getting so far down the planning road, and then all of a sudden they're sprung on the public that may suspect things or may not. But then you've got so many resources poured into it already, and so many stakeholders already have some idea that, this thing is coming, that the idea of opposing it it creates all sorts of conflict in the community too. So I worry about that. And I would agree, Senator Hauschild, Google coming in that's done this, quite frankly, they're skilled at these things, and they're skilled at playing communities off against each other. They're dealing with local city council members that probably have never had any experience of any sort like this. It feels unequal in that sense. But, the letter from the chamber mentioned limited confidentiality, which in one paragraph, which I took to mean durationally from the start until some point in the process at which the project is unveiled. But earlier it said, in the paragraph above, it says some level of confidentiality, which suggests to me maybe there are some things that could be disclosed to the community, but some things like particularly sensitive business information that maybe wouldn't be disclosed to a community or available to competitors. Has there been any conversation or thought given to limited NDAs to protect confidential business information, but would still give the community the heads up that someone's planning a 500-acre development here that's going to be drawing 1,000 gallons a second from the aquifer underneath it, is going to make Lake Wobegon go down 2 feet, and docks having to be extended or whatever it is to be able to get to your boat. It sounds like there might be some nuance in here that could apply to some kind of limited NDAs. Has there been some discussion, Senator Hauschild, in that regard, or is the idea that, or do you think that just frankly the cost of the NDAs so outweigh the benefits of disclosure in every regard that we should just ban them altogether? Senator Hauschild.
Thanks for the thoughtful question, Mr. Chair. I have not heard from any stakeholders with that type of idea. So it's an interesting one, and one certainly that I'd be willing to at least have conversations with various stakeholders about if there's a better way to ensure transparency in our communities while ensuring economic, opportunity in Minnesota. I'm happy to have those conversations with folks. But in terms of your pointed question, no, I have not had any specific conversations about that type of idea, and would be open to those that are working on this to come to me with those ideas.
Yeah, I guess my inclination, I would support a ban on NDAs, but I can envision some limitations on that ban where, proprietary financial information for a company,
Right.
or if they're proprietary scientific processes that they want to use in their data center that gives them a competitive advantage against some other company that wants to do a data center 5 miles down the road or across the bay in Wisconsin, or whatever the situation is. There ought to be some room for that, just like any other development where they've got some room to keep proprietary business information private while still giving the community a heads up that there's a massive project that's being considered and could have substantial impact in the community. So the community, it's not a matter to me of being, can they mobilize, do they have time to mobilize or not mobilize the resources to oppose this, but that they have sufficient information as a community to make an informed decision. And that includes not just the elected officials making informed decisions, but everyone in the community having the information to participate in that kind of a process.
Yeah.
Any further thoughts, Senator Kroon?
Thank you, Mr. Chair. I'm just wondering, I kind of understand the idea of an elected official entering into an NDA individually or even in their capacity as city council member. I get that, but that also includes employees. And I'm just wondering, I'm assuming that if a data center comes to a city and they enter into discussions, that a city manager or city administrator isn't going to be able to ultimately effectuate the final deal. It's going to take city council approval. What's the harm in a city council essentially deputizing a city employee to go out and negotiate with these data centers? There could be proprietary information involved at that point. That city manager or designee, with city council approval, signs the NDA. And then when they come back, if it goes anywhere, to the city council, this is the best deal we can get, or these are the terms, then that's all transparent. None of the elected officials are signing an NDA or subject to an NDA. I guess ultimately my question is, why does your bill have to include employees as well?
Senator Hauschild.
Thank you, Mr. Chair, and thank you, Senator Cruen. The bill was amended in state and local government to include local officials. It was drafted as elected officials. However, as a former city councilor, I can dream up hypothetical scenarios where what you're describing could also be a challenge in a different way, where the elected officials who are elected with an election certificate from the people of that community or county are making decisions that could impact a future project that they are unaware of because staff have signed an NDA. And so as a city councilor or a mayor, I sure hope when I'm meeting with my staff that I am fully aware of all the things that they are aware of when considering decisions that could impact that project. And so that's where I think I was sort of, I drafted the bill elected officials because that's what was asked of me by the community. But through the discussions on the state and local, that was kind of the way that I started thinking about it, is there's kind of another problem with the way you're describing it.
Mr. Chair.
Senator Cruen.
Thank you, Mr. Chair. I appreciate that. I imagine there could be potential problems with any scenario, but I'm envisioning a scenario where the city manager or the city administrator has no authority to bind the city to anything. They have the authority as that council gives them to go negotiate and sign an NDA as part of those negotiations. They're not binding the city to anything. So decisions that are affecting the city aren't being made subject to the NDA. It's simply a negotiation. And this would all have to be, the terms of the designee's authority would all be transparent, because the city council would essentially need to deputize this person to go and sign the NDA and then to go and enter into negotiations with whoever. And then if whatever the final deal or whatever is contemplated comes back to the city council for consideration, not subject to NDA, fully transparent, I think it could help bolster economic activity while not having any of the ultimate decision makers involved in the confidentiality that an NDA brings with it. So I don't know if that's something to consider as this bill moves forward, whether employee should stay in the bill or go back to the way it was originally introduced. But I can see some value in just having it apply to the elected officials.
Any final words before we lay the bill over, Senator Hauschild?
No, I really appreciate the opportunity for a hearing, Mr. Chair, and definitely a critical discussion for us as we move forward here in the state Senate.
Thank you for bringing this forward to us. Senate File 4548 is laid over. Senator Pappas, Senate File 5117.
We've got it. I'm not sure.
Let this in just under the wire.
But someone else, and then she's gonna put those amendments in there. It's technical, but this is the first year.
Okay, Senator Pappas, we have Senate File 5117 before us, and this is the first committee stop. There's an A1 amendment, which would be an author's amendment. Senator Pappas moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Pappas, tell us about your bill.
Thank you, Mr. Chairman, and thank you for squeezing me in today. The Ramsey County Attorney's Office responded to a request for proposal issued by the Office of Justice Programs, the Minnesota Department of Public Safety in 2025. The RFP requested proposals under the 2025 Crossover Youth Practice Model Dual Status Youth Initiative with funding appropriated by a previous legislature. The program timeline for the grant award was 18 months from June 25 through December 15th, 2026. OJP subsequently selected Ramsey County Attorney's Office to receive grant funding under this program, and their grant agreement with Ramsey County and the award letter included the end date of December 15th, 2026. OJP notified Ramsey County that the grant agreement will end on June 30th, however, 2026, making it difficult for Ramsey County Attorney's Office staff to finish the grant work product. So we wanted to clarify with the amendment and the bill that the end date is December 15th, 2026, to align with the original date that was in the grant agreement. And Mr. Clark, Sam Clark, is Chief Deputy from Ramsey County Attorney's Office. He's available to answer any questions from members of the committee or to say anything I missed.
So Senator Pappas, we got an 11-page bill here to change 2 lines in the middle of it. Is that pretty much it? The
why is
availability
that?
date on page 3 that we're addressing.
We'd have to ask staff why we have to have an 11-page bill.
No, I'm sure it's because it's all one section. It's one big subdivision or section. All right, any questions from members of the committee for Senator Pappas or for the testifier? Members, the intention is to lay this bill over, as I understand, correct, Senator Pappas?
Yes, Mr. Chair, because it involves money, it can't really go on its own.
All right. Senator Holmstrom, are you reaching for the microphone to ask a question or make a comment, or are you just stretching?
I have a question.
Okay, Senator Holmstrom.
Thank you, Mr. Chair. Senator Pappas, if not extended, the remaining money would go back to the general fund. Is that correct?
Mr. Chairman
Pappas.
and Senator, or they would have to hurry up and spend it. And I would just, that doesn't sound like a very efficient way to run a program.
Senator Holmstrom.
Thank you, Mr. Chair. I'm sure nobody in government would inappropriately or rush to spend funds just to not lose them. So thank you for answering the question.
Especially not for this very important purpose.
Well, Mr. Clark may want to
Senator
comment
Pappas.
on that, I don't know.
Mr. Clark, care to wade in?
Mr. Chair, Senator, I agree with Senator Pappas.
Oh. Someday you're going to be elected to something. All right, not seeing any further discussion, Senate File 4067 Senate File 5117 as amended is laid over. Members, next item up, Senate File 4067, Courts Supplemental Appropriation. Going to hand the gavel over to the Vice Chair. Yeah, come on. You can go.
Here's it with Claire.
Jeff, you can come on up. How are you doing?
Good, how are you?
Happy tax day. Yeah, thanks.
All right, Senator Latz, I see the A2 amendment. Would you like to walk us through that amendment to begin?
Yes, Madam Chair, I move adoption of the A2 amendment as an author's amendment.
All right, Senator Latz moves adoption of the A2 amendment. It's an author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails and the amendment's adopted. Senator Latz.
Thank you, Madam Chair and members. This is a response to the request from the Minnesota Judicial Branch for a supplemental budget and some policy changes with regard to safety and security for the branch. So I have with me State Court Administrator Jeff Shorba, who can explain the court's position on this, and I have Mr. Turner, who can go in more detail with regard to the appropriations.
Mr. Shorba.
Madam Chair, Chair Latz, Senator Limmer, members of the committee, we are obviously very supportive of this bill. We appreciate the fact that the committee is recognizing that courts, like other public institutions, are operating in a time of very heightened safety concerns. Across the country and here in Minnesota, judicial officers and court staff are facing increasing threats, harassment, and other risks tied to the work of the courts. And as you know, this is really an access to justice issue. If the courts are not seen as safe, people are less likely to come to court for their problems. So people must be able to come to work as our employees, to court as our judges, and fulfill their responsibilities without fear or intimidation. So the funding in this bill will allow us to take meaningful steps to address these safety concerns. It will strengthen our ability to assess and respond to threats, improve coordination with law enforcement, expand training and emergency preparedness, and enhance protections for judges both online and at home. The funding will also, through our grant program, support improvements in courthouses across the state. We also appreciate the funding in the bill for an operational adjustment for the judicial branch. This funding will help us sustain core court operations and continue serving court users across Minnesota in the way they expect and deserve. So I can answer any questions about details about the bill, but we are very supportive of the bill in its current form.
Any questions for Mr. Shorbaum? Senator Limmer.
Thank you, Madam Chair. Mr. Shorbaum, I was looking over the bill. As you know, in practice, I'm in support of such legislation, but I did have a question on page 1. Well, have we considered the A2 amendment yet? Maybe I'm getting ahead of myself. I'm not getting ahead of myself. Page 1, line 12. This bill, if passed into law, would classify a work telephone number as private data. I guess I'm kind of curious. A work phone number, to me, does not seem as closely imminent to a judge as compared to a legislator, let's say. We're always open for comment. Some legislators prefer to get all their calls at work, but that's not considered private data. It's part of our representational branch of government where we are to stay close to the public. But why would a work telephone number need to be deemed as private data? Does not the public have a right to contact a judge's office?
Mr. Shorbaum.
Madam Chair, Senator Limmer, the A2 amendment was not an amendment put forward by the judicial branch. I'm not opposed to the amendment, but I did not author the amendment and we did not suggest the amendment. So someone else will have to answer that question, unfortunately.
Perhaps I could ask that question of whoever the author of the A2 amendment is.
I believe Senator Westland wanted to chime in. Senator Westland.
I'm not the author of the A2, but I guess what I would suggest is that generally speaking, we do not direct calls directly to any judicial officer. They typically go through court administration or their clerk. So if I have a question on a case, for example, I'm not calling the judge. In fact, it would be inappropriate for me to do that. I don't know if that's the reason for this or not, but generally speaking, I would not have a direct line to a judicial officer.
Madam Chair.
I'm going to go to Senator Latz and then back to you, Senator Limmer. Senator Latz.
Madam Chair, Senator Limmer, as I read this, it doesn't necessarily classify the data that exists in any other place as government data, but it just says the information submitted under subdivision 2. So the way I would read the amendment is once the data is submitted to the Commissioner of Public Safety, that submitted data within the Commissioner of Public Safety's repository is considered that not public or that private data. That doesn't mean if it's available in some other form in some other location that it has any classification.
I see.
That's the way I would read it.
Thank you,
Senator Limmer.
Madam Chair. Is there a directory in the state of Minnesota that actually has a telephone number of a justice? And in reference to what Senator Westland said, why would we even want to have their phone number listed then?
Senator Latz.
Well, Madam Chair, Senator Limmer, there are chambers phone numbers available, I believe, in public directories. I've got an attorney secretarial handbook at my law office that lists chambers phone numbers for judges and staff and court administration all over the state and a whole lot of other government-related offices. In terms of a direct dial line to the phone on the desk of the judge, I doubt very much that it's in there unless that judge has a multi-line phone and they can see. If a number's coming in the chambers, it's one thing. If it's coming in a private line, maybe it's spouse or child calling and not, or probably now it's all cell phones anyway.
Well, I was just raising it, Madam Chair.
Senator Limmer.
Kind of new at understanding the judicial branch of government, so just thought I'd ask these questions. Thank you.
Senator Kroon.
Thank you, Madam Chair. I was just going to chime in on that, but if, given Senator Latz's explanation on what this, how this actually operates once it gets submitted, I don't think it really matters, but I was just going to chime in about the difference between the general number for the office of the judge and the direct line. Because we do want, I would want the general chambers number to be public. I mean, there are times where we as lawyers, or imagine the public, has to get a hold of chambers. You know, something happens, you're gonna miss a hearing for an emergency purpose or whatever, you want that message to at least get to the law clerk so that it can get to the judge, but certainly you don't need the direct line to the judge to be public, and I was just gonna make that distinction. But given how this is worded, I don't think an amendment is necessary.
Senator Latz.
Yeah, sometimes it's trying to get hold of a judge and to say that we just got scheduled for a floor session, I can't make it to the hearing. That's
Yep.
We do have Mr. Turner here to go through the numbers, Madam Chair.
I think we had one more comment from Senator West. Okay. Mr. Turner. Go ahead, Mr. Turner.
Thank you, Madam Chair and members. I'll quickly go through the spreadsheet that's in your packets. Starting with the Supreme Court on line 3 of the spreadsheet, we have a one-time operating adjustment of $250,000 in fiscal year 26. It's available until the end of fiscal year 27. On line 4, we have the safety and security package, $529,000 in 27, with tails in 28 and 29 of $488,000 each year. And we have a one-time appropriation for safe and secure courthouse grants, $1 million in fiscal year 27. Again, one time, no tails. And then on line 6, 14, and 22, we have a fiscal year 28-29 tails adjustment. This is the result of last year's bill. At the end, the court, the way we funded the tails, the court requested a redirection or redistribution of these numbers. And as you can see on line 6, the Supreme Court, we add $815,000. On line 14, we add $77,000 to the appeals court. And on line 22, we subtract $892,000, which is an equal amount, so the tails adjustments are budget neutral. Then again, in the appeals court, line 12, we have an operating adjustment of $70,000 in fiscal year 26. It's available until the end of the biennium on fiscal year 27. The safety and security package at $82,000 in 27. With tails of $53,000 each year in 28 and 29. And then the tails adjustment that I just spoke to. District courts, again, we have an operating adjustment one time of $1,600,000 available till the end of fiscal year 27. And then on line 21, the safety and security package, $1,276,000 in fiscal year '27, with tails of $824,000 each year in '28 and '29. And then the district court tails adjustment on line 22. And that's the bill.
All right, any questions, members? All right, I'm not seeing any. Give a motion, Senator Latz.
Thank you, Madam Chair. I move that Senate File 4067 as amended be recommended to pass and be re-referred to the Senate Committee on Finance.
All right, Senator Latz moves that Senate File 4067 as amended be recommended to pass and sent to the Senate Committee on Finance. All those in favor say aye.
Aye.
Any opposed? Motion prevails and is on its way to Finance. Thank you.
Thank you.
Thank you, guys.
For the reviser's bill. It's heavy. It's going to take us a minute to pass it out.
Senator Limmer, if you want to step to the testifier table for Senate File 4244.
Right here's it's a shame to say goodbye to all this, but I will certainly miss
Here
it.
it is.
And I really miss this here.
And then it's up to you if you want to execute for that part or
Gotcha.
whatever else. But
All right.
That's the way it's supposed to be. It is the way it's supposed to be.
Now, members, the highlight of the hearing today, Senate File 46, nope, Senate File 4244, the reviser's bill, one of the thickest bills of the legislative session. So if we don't finish by 2:30, we'll come back at 6 and stay as long as we need to walk through the bill. Is this an amendment? It's just explanation. Okay, so members, you have the bill and you also have an explanation summarizing each paragraph here. We have, this is an annual bill for those of you new to this process. It's basically, it's our cleanup bill that we do technical corrections, obsolete references, things that got picked up from everything we did last year that needs to be cleaned up this year. It happens that way. We do it all the time, but it needs to be done to keep our statutes clean. So we have with us our reviser of statutes, Jeff Case. Why don't you go ahead and introduce yourself and tell us whatever you'd like us to know about the bill.
All right. Why don't I begin first?
Senator Limmer, you want to go first?
Yes. Mr. Chair and members, we have a bill, reviser's bill. As you said, it's the annual reviser's bill. Page 1 through page 220 is before us. I'm sure you all have a copy of it. And we can start on page 1. No one picked up on that. Is anyone listening?
Is this thing on?
Yeah, right. As you know, the reviser's bill corrects technical errors in statutes, laws. It corrects erroneous and incomplete cross-references and internal references. It corrects grammatical errors and miscellaneous drafting, engrossing, or other errors. Today I have Jeff Case from the reviser's office that is anxious to regale you with all of the details in this bill.
Mr. Case, welcome to the committee. Your
Thank you,
annual
Mr.
trek
Chair.
to the Capitol.
Thank you. Thank you, Mr. Chair and members of the committee. My name is Jeff Case. I'm here on behalf of the Revisor's Office. As Senator Limmer said, this is our annual bill making a variety of technical corrections to the laws and statutes. The one thing I would add is that we are very cautious about making sure that all of the sections contained in the bill are technical in nature and not controversial in the legislature. We have a thorough process of internal review, and before the bill is introduced, we share that bill with the Office of Senate Counsel Research and Fiscal Analysis, as well as the House Research Department, and I'd be happy to answer any questions.
Any questions from members of the committee? Senator Kroon.
Thank you, Mr. Chair. On page 193, section 204, it strikes the, on lines 3 and 4, it strikes the dates 1971 and 1972, and the explanation is that it removes obsolete language. What is the reviser's kind of standards for when those dates that we see sprinkled throughout the statute books become obsolete? Is there a certain number of years you wait, or once it's functionally obsolete and you see it, you get rid of it? What's your decision-making process on that?
Is your question directed at Senator Limmer or Mr. Case? Mr. Case.
Thank you, Senator. I think the standard would generally be when it's functionally obsolete. If there are reasons when we do any research or look into it that date would be significant or substantial to include, we wouldn't touch it if based on that feedback. Reason that a date that is this old might come up and be included in the bill is just in the process of editing the statutes. When we review that, someone might see this and it just hasn't occurred to anyone. And they would say, I'm just going to include it in the bill. But typically, we wouldn't have a date that is this old. But we do have old sections. In fact, there is a section in this bill that was brought to my attention from Senate Counsel, in fact, which is an old statute just relating to when the Court of Appeals was created by a constitutional amendment adopted by the people. It went back to 1982. Again, that's been on the books for some time, but it was obviously obsolete, and we just try and clean up as best as we can to improve the accuracy and utility of the publication and make sure that everything in it is relevant and up to date.
Senator Kroon.
Thank you, Mr. Chair, and thank you for that explanation. I think it's probably good to do this when you're amending some other provision in the same area of the statute books. I get it. From a practitioner standpoint, I kind of like to see the old dates in there because it's kind of a cheat sheet, so I know when the law was enacted, so I don't have to go searching other places to figure out when it was enacted. But having said that, this is probably a better practice, so thank you for that explanation.
Any other questions or discussion from members of the committee? Is there anyone in the room that wishes to testify in favor of the bill? In favor of the bill? Anyone in the room wish to testify in opposition to the bill?
Oh, no.
Mr. Carlson.
Thank you, Mr. Chair and members. I'm Joel Carlson. I'm here on behalf of everybody. And I have a few questions for Senator Limmer on this bill. And Mr. Case, you might want to take a seat because these are only for Senator Limmer. Senator Limmer, you so artfully on page 16 at line 25 went to a numeric, or excuse me, an alphabet system of laying out the bill. But then you completely reverse yourself on page 25, line 23, and go back to a numeric system. Can you tell me why you would bring such an inconsistently drafted bill in front of this committee after being taught by Senator Higgins and so many others how to properly draft a bill?
Mr. Chairman?
Senator Limmer.
That's to provide job security for the revisor's office.
Senator Limmer and I started together. I started my lobbying business in 1989, the year that he was a freshman in the Minnesota House. And over that time, we have worked on dozens and dozens of bills We've had countless meetings. Angela, thank you for allowing me to get in every time I've asked. Oh, you tried to block one time, but only one time.
Only one?
You know, and I can tell you that lobbying Senator Limmer has been more stressful than it has been for him having an election certificate. My evidence of that is that despite the vast difference in our age, he's retained his hair and boyish good looks, and me, not so much. The first bill I worked on with Senator Limmer was a bill that he carried to provide justice to people who had received unknowingly tainted blood products in 1997. And you have worked to provide and require accountability from individuals and corporations ever since that date. The trial lawyers have recognized you on numerous occasions for your work. You've supported victims of crime, battered women, children, the bill we did on impaired drivers. Excuse me. You and I met with Allison Olson, a 21-year-old woman. Her boyfriend broke into her apartment, knocked her down, pulled the phone out of the wall, strangled her until she blacked out. He was arrested, and he was charged with a misdemeanor for strangling her almost to death. And he was charged with a felony felony for interrupting a 911 call. Right. In 2005, you fixed that by making strangulation of your domestic partner a felony. You've been a steadfast supporter of the Minnesota court systems and our access to it. You've sought fairness in family court for victims, particularly those that are going to lose their children in court when they try to escape abuse. I have dozens of memories in this very room. And we've also infamously killed a few bills in this committee in Senate Judiciary fashion, which is you debate a bill for an hour, hour and a half, you amend it 3 times, and then you defeat it. You've served with 5 governors. You've served under 6 different Judiciary Committee chairs and chaired this committee yourself for 6 years. A few data points for Senator Limmer. He's chief authored 682 bills. He has been asked to co-author bills by you, your colleagues, 1,375 times. And you need to know, Senator Limmer and I have not always been on the same side of every issue. In fact, we've been opponents dozens of times, but we've never let policy differences stand between our work and our personal friendship. We still enjoy our affection for the outdoors and ducks and pontoons. You need a new one, by the way. Yeah. And the love of our work in this building. I laughed out loud when I was in committee the other night when you sent me your the inside cap when Senator Seeberger's bill was up about now learning that you had agreed to binding arbitration by using a product, just by opening it up. And I laughed twice. Once that you were reading the inside of the label, which is totally a Limmer move, but also that you were so hip and cool that you were taking a collagen protein shake to improve your looks.
I'm getting older.
So the governor didn't always agree with your work. You drew vetoes from Governor Carlson, Ventura, and Dayton. You had one bill that I particularly hated, and I wanted to leave you with a signed copy of Governor Dayton's veto letter of that bill. And I want to give to you something I have saved for a long, long time. This is the only remaining Warren Limmer for Secretary of State button. Now, Mary Kiffmeyer stole the endorsement by baking bread and jam for all of the delegates.
Yeah.
But I really wanted you to win. It wasn't just a chance to open up your seat for someone else to have a free pass without beating an incumbent. So, Senator Limmer, I want you to have this. I'm going to sign your reviser's bill, and I want everyone else to sign it when they come up. Thank you for everything, my friend. It's been great fun, and you'll be greatly missed.
Thank you.
Thank you.
Thank you, Joel. Did you?
Who's next? Come on forward, introduce yourself, testify as you will before the committee.
Mr. Chair, members of the committee, Senator Limmer.
Judy?
My name is Judy Cook, and I am here today on my own behalf to thank Senator Limmer for all our years. I actually remember when you came to the legislature, to the House. A little worried that makes us both old, but
Not really.
we've had, Joel did an amazing job with all of the stats, but, you know, there are very few people throughout my many years here who've been the statesmen that you have really been. We've gotten along. We got a hospital for your district, the Maple Grove Hospital, and we've gone round and round and round on a lot of data privacy stuff over the years, and worked on bills and maybe killed a few as well.
Sure.
I apologize for the times I've yelled at you, because that may have happened, but just really, we will miss you, for sure. I will miss you and appreciate all the great times and appreciate you.
Thank you.
I want a hug.
Of course.
I always follow my colleague Judy. That's a better way to clean things up. My name is Mo Shaver, Shaver Public Affairs, and I stepped first in this building when Governor Quee was governor. I have known Senator Limmer a long time, and I'm just here to thank him for his public service, thank all of you for your public service, but as the spouse of a former member, I'd also like to recognize your wife, Lori.
By all means. Yeah.
And your family, because they have given a lot, as all of your families do, to endure this profession. And I just wanted to say thank you and congratulations.
Thank you. Thank you.
I'll sign it.
Oh, no. Who else is back here?
Mr. Chair, members, Ron Elwood, also on behalf of myself, before I start my testimony, I'd like to just point out that, you know, some people think that Joel Carlson and I are the same person. But now we are here in the same room, so two things would be dispelled. One is we're not the same person, and two is I'm much better looking than he is. So I set foot in this building 27 years ago, and as a rookie, I felt, what am I doing here? And I'm never going to be as well-respected as Joel Carlson and Judy Cook and all my friends and lobbyists and who are powerful. And when the legislators get off from the table and go sit down next to somebody and start schmoozing with them, that'll never happen to me. And the first person who did that was Senator Limmer. And Senator Limmer, when he sat down next to me and started schmoozing with me, said, I felt I now belong here. I feel accepted. I'm part of the club. I'm sure he's sorry he ever did that. But, and I don't think he ever voted for one of my bills, but no, he has. That's not true. But I also want to thank you, Senator Limmer, for your kindness to me, your service, and the way you have comported yourself. And in closing, I just want to say I don't think this bill is ready for prime time, and I think it needs more work.
Here. Thank you. Brian.
Mr. Chair, Brian Lake, representing myself. I just wanted to say, first of all, on behalf of the Bar Association and the broader legal community, how much we've appreciated Senator Limmer's staunch support for an adequately funded justice system over the years, including, as some of you might recall, in 2011 during probably the toughest budget cycle the state has seen in decades. And that's my most prominent memory of his many legislative accomplishments. But I think beyond that, the really important things about him are this committee, of course, you have your partisan spats now and then, and that's to be expected in this body. But I think more than any other committee, you work together as a bipartisan unit to improve the legislation that comes before you. And I think Senator Limmer, as a member, as a minority lead, and as chair of this committee, has done as much as anyone to foster and steward that tradition. And he has done it with tremendous class and dignity that reflects the best of this body, and he's going to be sorely missed.
Thank you, Brian. Appreciate it.
I wasn't going to
How much time do we have?
I think I'm the last one because Nancy Haas couldn't make it.
Okay.
Oh, she's here. Are you coming up?
We've got as much time as we need, Senator Limmer.
I'm Carla Ferrucci, and I'm here also on behalf of myself. And I want to thank you, Senator Limmer, because as a baby lobbyist, my first time testifying up here, I was shaking. I'm kind of shaking now. I was here on behalf of victims of sexual violence. And I think you knew I was scared, and you coached me. You weren't even the chair. You were sitting where Senator Seeberger is sitting now. And you helped me through my testimony, and I will never forget it. You've always had an open door for us, even though now I'm at the trial lawyers, and I'm not with victims. But you've always been open. You've always taught me stuff if I've ever screwed anything up. And I've really appreciated it. You're gonna be missed. Brian just said it, but when things get really partisan up here, you always have had an open door, no matter whether you agree with us or not. We've always found common ground. And on behalf of the victims of domestic and sexual violence in the state, I want to thank you for all that you've done all these years. You've impacted so many lives. I hope you know that, including a lot of us that work in this building. So thank you.
Thank you.
I'm gonna give you a hug, too.
Oh, boy, they just keep coming.
I'm Sarah Pasick, also here on myself. And it's hard to add anything. I'll just say when I was working in the House right out of college, you were there, and always great to visit with and talk to. You moved over to the Senate. You've been just a steady voice on this committee. I think Friday afternoons at 5 o'clock, not seeing you there with another really good question on a judiciary bill won't be the same, but I hope you enjoy your time now. You can always come hang out with the rest of us on Friday afternoons. Bring snacks, bring whatever, or not. You don't have to anymore. So thank you for all that you've done for everybody here.
Thank you. Oh, no.
Nancy Haas, on behalf of Pool Haas myself, but I would remiss if I didn't mention my clients, the district judges and the prosecutors, because I started in the House as a staff member and a CA for the Judiciary Committee in 1998. And through all of my 20 years of contract lobbying, every time I would see Senator Limmer, he would say, "Oh no, not you again." For real, he did it as I was walking up. But that was always a kind way to, have an opening to just chat and find out what we needed to talk about for the day. And so on behalf of just all of us, and we're just so appreciative for your kindness, for your ethic, and for all the contributions you've made that are too many to be able to talk about. But I'm glad to sign this bill as well.
Someone on high wants to contribute here.
Yeah.
Well, may we all aspire to have the legacy that you're leaving us with, Senator Limmer, when you retire this year.
Well, thank you, Senator Latz. After all these comments, maybe I should run again. But then again, I would have to face the wrath at home. So this has been a tremendous experience. As many of you know, I don't have a law degree. And the Judiciary Committee I've been on in my House years as well as in the Senate, 38 years straight. I love studying the law, despite the fact that I'm not anywhere close to being an attorney. But this has been truly a joy for me. Kid that was born in Sioux Falls, South Dakota, and raised in this working-class suburb of Crystal, Minnesota, I never thought I'd have a job like this, or to have the position of a chairman of the Minnesota Judiciary Committee. It's really a testimony to what America is all about. You can pursue anything, and oftentimes you'll accomplish that goal. I've created many good friends here on both sides of the aisle. And Senator Latz, I have a tremendous respect for you. I know we have a friendship. We disagree on things, but that's the arena that we play in. And it's vitally important to keep relationships strong. I hope to keep relationships with all of you beyond my time here. I'm sure there'll be times when I'm going to be yelling at a television set or mentioning, well, my wife has reminded me I do that now. But I'll point at the television and say, you're missing the point, you're missing the point, bring it back. And so I know it's still in my heart to follow legislation. I don't know what I'm going to be doing after this point. I'm going to take a long rest, get away, see what the rest of the world is really all about, especially in the winter months. And I will be certainly following, but thinking of you all, and very anxious to see what the rest of the world and the rest of my life is going to turn into. I really want to follow politics beyond this, but from the outside looking in. Not sure if I'll come back and darken the hallways here officially or unofficially as a citizen, but you all will be held in my heart, and I'll be praying for all of you to have good decisions and good discernment as you weigh the problems and the solutions and even the opportunities that this state will have in the future. I don't think I better say anything more, Mr. Chair, but thank you for this. Thank you for today. Greatly appreciated. You really did sneak up on me. And I was actually talking to my assistant, Angela Cook, and I kept looking at the agenda saying, this is Wednesday. Why do we have such a short list of things to do? And now all has been revealed. So thank you again. Greatly appreciated.
Mr. Chairman.
Senator Pappas.
Thank you, Mr. Chairman. This has been a very lovely discussion, but I have to say that I just don't think this bill is ready for prime time. As the testifiers have indicated, we do not have clear definitions of erroneous and obsolete. They could be the same or overlapping, and I'm sorry, Mr. Case, it's just not very clear. So I want to move that Senate File 4244 be laid over for further discussion.
Mr. Chairman?
And I would like a vote on that, a roll call, and I want it recorded in the journal.
Are there 3 hands? I only see 2 hands. Oh, there's 3.
Mr. Chair?
Senator Limmer.
Senator Pappas has caused a flashback to me. I was hazed.
PTSD, perhaps?
I was hazed in my first year as a state representative. And Senator Pappas, being a representative of that time, was in on it. It was my very first bill that I presented, and I had a testifier from my community, traveled all the way over from Maple Grove and came in, gave testimony. Eric Eskla was sitting behind me in that little alcove in the house where people could sit. I gave my testimony, and Senator Pappas raised a similar question about the unclarity of the bill that I presented. and that I had not adequately informed the committee of the bill that was before us at the time. And before I could respond, she moved to not lay it on the table. It was to,
We actually see it.
yeah. And the testifier that I had, who was a friend of mine, he kept looking around the room saying, "What's happening? What's happening?" I said, "They're killing our bill." And he happened to be a bodybuilder. It was on anabolic steroids. And he was beginning to blow steam out of his ears. And it wasn't just Senator Pappas, it was others. They were all in on it. And so I happened to turn back, and Eric Escalate was sitting behind me. I said, "Gee, they really smoked me on that bill." And he looked at me, and he was looking at everyone else. He said, "No, they really smoked you." And I turned around, and everybody's snickering at the lead of Sandy Pappas. And so...
Well, if you remember, Mr. Chairman, if you remember then, I couldn't stand it. The look on your face, you just look so devastated that I moved reconsideration. And we passed the bill.
So I've been watching out for Sandy Pappas for 38 years.
Senator
Yeah.
Pappas withdraws her motion to lay the bill on the table. Senator Limmer, I know you claim not to be a lawyer, but you've been practicing law for a long time. So sometime between now and June 1st perhaps, or July 1st, watch your mailbox, see if you get anything from the Lawyers Board of Professional Responsibility.
Great. Is there a fine involved with that? Yeah.
Any further discussion on Senate File 4244? I'm not seeing any. Senator Limmer moves.
So moved, Mr. Chair.
Senate File 4244 be recommended to pass and be referred to the Senate floor. All those in favor, say aye.
Aye.
Aye. Opposed? The motion prevails. Members, we have an announcement to make. All members and staff are invited at this time to Capitol Room 323 for cake to celebrate Senator Limmer's years of service.
Wow.
Senators were emailed as well.
And all the staff were emailed as well. We will be meeting Friday, April 17th in the Minnesota Senate Building, Room 1200, convening at 9:30 a.m. We are adjourned.